Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. We're back. All right, it took me a minute how to download the stuff and things, and who knows, we could be here for quite some time. Must be a ton of emotions. Yeah, I also had to refill my hot coffee and my iced coffee. Sorry if I kept you waiting too long. Sorry. But yeah, there are a lot of filings here. All right. First thing up. Let me try and do this in chronological order. These are the new droppings. Good morning, everyone. Good morning again. Today is Monday, March 3rd. It is now noon, a little after 12 p.m. on the East Coast. And John O'Keefe still did not get hit by a car, and a car did not hit John O'Keefe. And Karen Reed was still framed. So there's that. I'm going to ask you, I shouldn't have to ask you this. I feel like I shouldn't have to say it, but I feel like based on some of the stuff that's flying by in the chat and that I saw in the other chat, I'm going to ask you very kindly to please not go after Vinny for some of the things that you may not agree with that he said. I feel like I shouldn't have to say it, but I feel like I do have to say it. So if you could kindly refrain from that. He's entitled to his opinions, as are we, and I would ask that you don't go after him personally. It's just, I don't know. I feel like I shouldn't have to say it. You guys should really be above that. But if you can't refrain, then, the mods are here and they know what to do. It's sad. It's sad. And also, here's the thing. He said, before he gave us his opinion about drinking and driving, he said that when he was a child, his neighbors, I think he said 3 children and the parents were all killed in a drunk driving accident. Every single juror that comes into the jury room brings with them their personal experiences. Okay? They just do. Jurors do not leave their common sense at the door. And they also do not leave their personal experiences at the door. And I didn't know that about Vinny. And I could see where he is coming from on that. He also said he thinks there's tremendous reasonable doubt. He does not think the prosecution has tried their case. He thinks that the prosecution is playing dirty. He thinks that Alan Jackson should not be thrown off the case. He thinks that a lot of horrific things are going on here. It is sad that we have to say it, but we do. So I have been a fan of Vinny since he started covering OJ on Court TV, and I thought it was very gracious of him to come on the show and to give us over an hour of his time. So I am very happy that he did that. I'm very happy that I got to know him a little bit better. And we're not always going to agree on everything, but he does agree that the burden is on the prosecution and they did not prove their case and that there's tons of reasonable doubt. Okay. Here we go. Starting with the new droppings from today, because it's Monday. This is docket number 532, which I think is the first one. I'm going to try and do this in chronological order. So 532 is here. And it is the defendant's motion for reconsideration, a portion of the February 18th, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. Got to get out my red pen. So, it's pink today. Maybe I'll just leave it pink. I was reviewing some documents the other day and I had different colors for different things. Like pink meant things I got to go back and look at later. And also red meant things that I thought were important. This is 11 pages. So settle in. Maybe you want to get yourselves a little something to drink. Okay. If you've already read these, please no spoilers because I have not read them yet. And so this will be for me a cold read. As we say in the biz, it's a cold read. Coming in hot. Now comes the defendant, Karen Reed, and respectfully request that this court reconsider the portion of its February 18th, 2025 court order, February 18th order, denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. In denying the defendant's request for metadata underlying these critical videos in law enforcement custody, the court indicated that, quote, there is no affidavit of an expert or any evidence before the court that the procedure agreed to by skilled counsel for both parties would result in the destruction of metadata. In light of the court's ruling, defendant submits the supplemental affidavit of defense expert Matthew Erickson, which establishes that the procedure proposed by the Commonwealth and ordered by the court will result in the destruction of relevant metadata that is critical to Ms. Reed's defense and is necessary in order to verify the authenticity of any additional Canton Police Department video surveillance footage that are produced in connection with this case. As the court aptly recognized, pursuant to Massachusetts Rule of Criminal Procedure 14B1G, effective March 1st, 2025, the prosecution shall disclose to the defense all photographs, videos, and audio recordings or other tangible objects, that's bolded and italicized, in the constructive possession of the Commonwealth, provided it is relevant to the case. The metadata underlying the Canton Police Department Sally Port garage videos is clearly a relevant tangible object in the constructive possession of the Commonwealth, which directly bears on the accuracy, authenticity, and reliability of critical video surveillance evidence in this case. In short, by simply dragging and dropping files from the Canton Police Department's video file system to a USB, the relevant metadata necessary to verify the accuracy, authenticity, and information associated with the creation and storage of that information will be destroyed. So, whereas Hank Brennan was like, it's just a simple click and drop, clip and drop. Their expert is now saying, Erickson, that the metadata will be destroyed if they do that. Moreover, the defense rejects the notion that there was an agreement by all parties regarding the proposed procedure for obtaining the additional Canton Police Department Sally Port videos in the possession of the Commonwealth. The defense was misinformed regarding the source and import of the additional Canton Police Department Sally Port videos during its initial conversation with the Commonwealth, i.e., the defense was led to believe that a retired detective's work cloud account or computer may have a copy of one or some or perhaps none of the videos, and then were later informed by the Commonwealth via email that the device at issue was the Canton Police Department's video file system. Upon learning of the correct source of the additional Canton Police Department Sally Port footage, i.e., the Canton Police Department file system, The defense immediately objected to the procedure proposed by the Commonwealth. An agreement by necessity requires a meeting of the minds by all parties. Yes, meeting of the minds as it relates to all material facts. Oops. That did not occur here. Indeed, yesterday at 3:30 p.m. on Friday, February 28th, after this issue was litigated before this court, the defense received. Wait, what happened here? Why didn't this make like a nice line? Hold on. I can't have that. I can't have that sit there. No, 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 no. The defense received for the first time a report from the Commonwealth dated February 27, 2025 from Sergeant Paul D. Giampietro detailing an after-the-fact chronology of his purported handling of the Canton Police Department video surveillance footage in this case. Oh, here we go. Here we go. So it's dated. They got it yesterday. Oh, thank you, Tom Kokonowski. Thank you so much. Appreciate you. They say yesterday. This is dated. What did I say this was dated? Friday. So they got this on Friday. This new chain of custody report. The retired detective who had to give up his tea time to get to it because, typing is hard. In bold print and underlined and italicized, it says, according to this new report, which was not produced by the Commonwealth until after the hearing on this issue, Sergeant D.G. Ampietro is claiming that he was responsible for downloading all of the video surveillance footage from the Canton PD in this case. Exhibit A, February 27th, report by Sergeant Paul D.G. Ampietro. He's retired, right? According to Sergeant D.G. Ampietro, he downloaded certain of these videos, including the, quote, inverted video, onto what he refers to as the, quote, detective drive, end quote. That detective drive purports to contain the critical video surveillance footage at issue, which will be presented by both the Commonwealth and the defense at trial. The defendant has a constitutional right to obtain and present evidence relating to the authenticity of this video surveillance, the authenticity of which, as set forth in defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody, is of critical importance to this case. Special Prosecutor Hank Brennan has been in contact with Sergeant D.G. Ampietro for months. This information should have been relayed to the defense prior to litigating these issues. Yeah, you think? You think? I mean, it's another one of those things that is really just so obvious that it shouldn't have to be brought up and mentioned. But apparently, in this world of the upside down, inside out, Narnia Matrix, it has to be. Has to be pointed out, has to be spelled out, has to be said louder for those people in the back because, not so obvious, I guess, to some people. As explained by the defense expert and computer IT and mobile device forensic analyst Matthew Erickson, if the Commonwealth has an individual simply drag and drop these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. Affidavit of Matthew Erickson at paragraph 7. The proper forensic protocol for preserving this critical information and obtaining the relevant data is as follows. A forensic image should be made of the operating system drive, as well as additional drives where these video copies may be stored, if stored on something other than the operating system drive. The operating system drive is critical in this situation as it will provide key information about the handling, modification, and creation of these video files. Without a forensic image of the operating system drive, all independent and forensically sound verification methods would be impossible to perform. Additionally, any relevant dates that are present in the available metadata would reflect the dates that the most recent copies were created and not the actual dates on which the initial copies of these video files were made. For these forensic drive images, we request that they are uncompressed, unsegmented, and preferably in raw DD format. And that is quoting from the affidavit of Matthew Erickson. You may recall that he was the forensic expert that flew from Phoenix in December to the Canton PD to pull the videos off of their DVR system. And then when he got there, Colleen Crawford looked at him and was like, "What are you doing here? What are you doing here?" There's no the Californians from from SNL. "Hey, Stuart, what are you doing here?" um, and then his trip was fruitless, and he was sent packing because they didn't know he was coming. If they knew he was coming, they'd have baked a cake, but they didn't know he was coming. And then they said, "Oops, that stuff doesn't exist anymore because it overwrites itself." So he was sent packing. Defense made a motion for their expenses regarding his trip, and that was quickly denied. Anyway, that's who Matthew Erickson is, to refresh your recollection in case your recollection is exhausted at this point. In light of the information detailed in the supplemental affidavit of defense expert Matthew Erickson and this new report authored by Sergeant D.G.A. Pietro, defendant respectfully requests that this court reconsider the portion of its February 18th order denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody and order the production of this information as is required by Massachusetts Rule of Criminal Procedure 14b1g and Ms. Reed's constitutional right to present a defense and to confront witnesses against her as guaranteed by the Massachusetts Declaration of Rights, Article 12, and the Sixth Amendment to the U.S. Constitution. Absent this court's swift intervention, defendant will suffer irreparable harm. XOXO. Karen Reed by her attorneys, Elizabeth Little. She's there. She's got her stilettos off. They're kicked under the desk, and she is cranking out these motions. Alan Jackson, David Unetti, notice they all signed these affidavits with a real signature. And Robert Alessi, I guess he couldn't sign this one, but from what I have been told by people attacking, is that maybe an electronic signature in Massachusetts is okay. So I stand corrected on that, if that is indeed true. However, the defense team does, for the most part, sign their motions with actual signatures. This is docket number 533, which is the supplemental affidavit of Elizabeth Little in support of the motion for reconsideration, because that's the way that motions are supposed to be filed. They are supposed to be submitted with an affidavit of a person swearing to the things that are in the papers as being the actual truth. 533. I, Elizabeth Little, hereby do depose and state the following is true to the best of my knowledge and belief. And I, for one, would like to just clarify that I am not in any way related to Elizabeth Little of the defense team. We are not related. I saw that being spewed around in some chats that I was watching on other channels, and we are not related. Somebody said we were, I don't know, she's probably young enough to be my daughter, but we are not related, for the record. I represent Karen Reed, pro hoc vice. The facts set forth in defendant's motion for reconsideration are true and correct to the best of my knowledge, information, and belief. Attached here too is Exhibit A, is a true and correct copy of the February 27th, 2025 report authored by Sergeant D.G.M. Pietro regarding his handling of evidence in this case, dating back to 2022. This report was produced to the defense by the Commonwealth on Friday, February 28th of 2025. Based on the new information submitted for this court's consideration, I respectfully request that this court allow defendant's motion for reconsideration of portion of February 28th, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the January 29th, 2022 video surveillance footage in law enforcement custody. Absent this court's swift intervention, Ms. Reed will suffer irreparable harm. Yeah, they need to get these files. They need to get them quickly. They need to get them with the metadata. Not a click and drag. It's not a click and drag. And this is 534, which is the affidavit of Matthew Erickson that they've now attached. I think the judge did say, if you have any more information, I can reconsider this. And so that's what they're doing now. Let me just close some of these unnecessary tabs. This is what did I say this docket number was? 536. Hold on. No. 534. Okay. Supplemental affidavit of defense expert Matthew Erickson in support of defendant's motion for reconsideration. So this was stamped this morning, March 3rd at 9:00 something a.m. I, Matthew Erickson, do hereby depose and state that the following is true to the best of my knowledge and belief. I am a computer, IT, and mobile device forensic analyst at USA Forensic, LLC. I was retained as an expert witness by defendant Karen Reed in the above captioned matter for the purpose of analyzing the current DVR configuration and obtaining forensic video surveillance evidence from the Canton PD. On December 11th, 2024, I traveled from Phoenix, Arizona to Boston, Massachusetts by plane to render expert witness services in the above captioned matter. The purpose of my trip was to allow me to extract surveillance video from the Canton PD's ExactVision or ExactVision. I like to call it ExactVision. It's probably wrong, but sounds nicer. ExactVision DVR system in a forensically sound manner, which aligns with methods accepted and commonly used in the digital forensic community, as well as review any video footage preserved within the system from January 29th, 2022, between 12 a.m. and 11:59 p.m. I visited the Canton Police Department on December 12th of 2024 to do so. After photographing the relevant DVR equipment, I began recording audio and video and then accessed the system. Initially, it appeared to me that there were only 30 days of video history, and consequently that the relevant footage had not been preserved. That impression was confirmed when I navigated to the appropriate section of the DVR system where a search by day and time could be performed, and I ran a search from January 29th, 2022, 12 a.m. to 11:59 p.m. The search returned 0 results. Based on the size of the drives, the percentage used, and the remaining usable drive space, I concluded that there was mathematically no possible way for the videos from January 29th of 2022 to be present in December of 2024 when I performed this search, unless they were manually saved and or properly preserved via standard forensic protocols. I determined that the relevant activity logs were also gone. Hopefully he'll get into this, but I think in order for those activity logs to be gone, they have to be like manually deleted, but I'm not sure. So it's going to be interesting. Oops. If he says this, let's see. The way Canton PD technicians extracted the video data from their DVR system is insufficient for forensic purposes and has resulted in the permanent loss of the original surveillance video data. The Canton PD DVR system, like most, stores videos in a proprietary format. Canton PD uses the DVR interface to pick and choose which videos to save, and then that data is converted by the system into a playable format. The resulting file is almost always of lesser quality than the original, and because it exists in a different format, the resulting file will not hash verify to the original. As such, forensic experts cannot properly test the authenticity and integrity of the video footage. Due to the Commonwealth's failure to preserve the original surveillance footage, I was unable to extract the DVR system footage from January 29th, 2022 to obtain relevant footage between 12 a.m. and 11:59 p.m. as previously arranged and agreed upon by all parties. I am informed that the Commonwealth may have additional video surveillance footage from January 29th, 2022 that is being stored on a separate electronic device known as the Canton Police Department's video file system. It is imperative that this additional source of information be preserved and dealt with in a forensically sound manner, as it may serve as another source of information relating to the authenticity and integrity of the video surveillance at issue in this case. If the Commonwealth has an individual simply drag and drop these files onto a USB drive, all associated metadata will be destroyed or otherwise unverifiable. The proper forensic protocol for preserving this critical information and obtaining the relevant data is as follows. And he's going to explain exactly what needs to be done. A forensic image should be made of the operating system drive, as well as additional drives where these video copies may be stored, if stored on something other than the operating system drive. The operating system drive is critical in this situation, as it will provide key information about the handling, modification, and creation of these video files. Without a forensic image of the operating system drive, all independent and forensically sound verification methods would be impossible to perform. Additionally, any relevant dates that are present in the available metadata would reflect the dates that the most recent copies were created, and not the actual dates on which the initial copies of these video files were made. For these forensic drive images, we request that they are uncompressed, unsegmented, and preferably in RAW format, DD format. Signed and sworn under the pains and penalties of perjury, March 2nd, 2025. Matthew Erickson actually signed it. He's the expert. And I am not an expert in computer forensics. I never said I was, but Matthew Erickson is the expert, and that's what he says needs to be done. No click and drop, no click and drag. Ain't going to happen. Ain't going to be forensically sound. And don't we want the evidence to be forensically sound and not altered or modified or tampered with in any way? I think we do. Hi, Kyle. I have so much pressing tasks today, and they're not getting done. It's all your fault. I'm so sorry. Why do you have to be so engaging? Look, it's a curse. It's a blessing and a curse, Kyle. I don't know. Thank you for your 5. I appreciate it. I was just joking. This is why I respect Melanie so much. Says, blessed mom from Texas. No one should be going after Vinny. Let's do better. Love. Yeah, nobody should be going after Vinny. Nobody should be going after Dr. Wolf's family and his wife and his children. Nobody should be going after Richard Green and trying to scare him away from testifying. I have never seen anything like the shenanigans and just vitriol and outright hatred and scary behavior by trolls on the internet that I've seen in this case. Thank you, blessed mom from Texas. Buzzing for Truth said it was great to have Vinny on. Thank you so much. Michelle says, new song for playlist, Pure Imagination. Oh yeah, from Willy Wonka, right? From Charlie and the Chocolate Factory. Listen, I like the old version, the Gene Wilder version. You're never going to convince me that Johnny Depp was a better Willy Wonka than Gene Wilder. I think Gene Wilder is the OG. And also, didn't Timothy Chalamet play Willy Wonka as well? Yeah. I say, sorry, I just got distracted by somebody putting a nasty comment on the last video. Like, really? You can't control yourself? Gene Wilder is the OG, and you're never going to convince me otherwise. Thank you, Michelle, for your super chat. On top, thank you so much for your super sticker. She rage knits. They should be compelled and then face consequences when they cannot comply. Yeah. But we don't ever see any ramifications for the behavior of the Commonwealth, do we? Have we seen anything ever? Have they been punished ever? Thank you, Tracy Walker, for gifting 10 memberships. You're amazing. hundreds of memberships gifted in the last couple of streams alone. I don't know where you came from, Tracy Walker, but we do appreciate you so very much. And for the 10 of you who were gifted, welcome, welcome, welcome. It's hash value, not hashtag, says. So much for the claim that they can't create evidence that does not exist. Eye roll, big eye roll. My eyes just rolled out of my head. It's not going to, it can't be admissible because chain of custody logs, as we discussed with Andrea Burkhart last night, need to be made contemporaneously with the custody. You can't all of a sudden, 3 years later, start making up a log. They wanted the logs that existed. The logs didn't exist. The judge said, Ms. Little, do you expect them to just create evidence that doesn't exist? And now they're creating evidence that didn't exist. It's wild. It's crazy. It's insane. I've never seen anything like it. That is the latest motion to reconsider the court's ruling on the last motion. So that was 532, 533, 534. Now, in order, we go to 535. These motions are supposed to be heard tomorrow and Wednesday. I don't know if there's been any determination on whether the motion to dismiss is going to be adjourned, because Hank Brennan, even though he was supposed to turn over additional Sally Port video today, opposed the motion for an adjournment to give the defense an opportunity to have their experts look at this new Sally Port video. So I'm just going to take a quick look here at the court docket and see if the judge did indicate whether or not that has been granted. So give me 1 second. Talk amongst yourselves. Let me take a sip. Talk amongst yourselves. Coffee talk. Okay, so where do we start? We started at 532. All right. Something else that hit the docket today is 531, which is the business records received from WFXT Boston 25, and that's on an external hard drive. And it says they put it in the vault. So apparently they've got a vault in Norfolk Superior Clerk's office. So that's interesting. I do not see any scrabble with regard to whether that motion to amend the court scheduling order has been granted or not. And so now we move on. To 535, but next to it in the docket, it says filed in error. Well, I have it, so I'm going to read it to you anyway. I don't know why it would say filed in error. Anybody have any inside scoop on that? Does Manning have the vault? Does Manning have the vault keys? Mudrucker wants to know. Zoe wants to know, are there paper files with videos inside that vault? Yeah, exactly. Alessi's binder is better than Breenan's binder. Says, any people familiar with the video systems like this in the chat? Just seems super sus that the access log would also be deleted, as there would not be the same sort of memory concerns as for video. I will tell you, I heard from a viewer who is very familiar with this exact Vision system, as this viewer works for a municipality in Massachusetts that uses this exact same system. This viewer told me that it is very possible, it is what they do when they need to put a video on a legal hold, to keep it in its original format on the original system so that it will not be overwritten. It is commonly done. They do it all the time in anticipation of litigation or other things, and it is something that they do. You can look up online the user manual for the exact Vision system. You can find it. It's out there. It's publicly available. And so you guys have the time. You are armchair detectives on this case. And I think that you can see that there is a way to put video on a legal hold. It doesn't have to be overwritten. I would imagine also, I don't know if the ExacuVision also is for the cameras or if that's just the video retention system. I don't know. Was the vault rehomed? But also, does it record inverted? Why do they have a video from January 1st of 2022 showing that it was always inverted if everything overwrites itself within 30 days? Why were they saving that particular day of video? And how do they still have it? I have so many questions. All they're doing is just increasing the number of questions that I have with regard to this case every time we read a filing. KCAT, how's the Norfolk County ADA named special counsel to represent the court in the federal case? Isn't that a conflict or ethics violation? We talked about this last night. I don't know the exact answer to it. Thank you for the super chat. But Caleb Schillinger has his name on the papers. He also represented the Commonwealth in their appeal to the SJC, and he argued for them there. He is their appellate counsel. I don't know if it's an ethics violation or a conflict. Andrea Burkhart seemed to think that it was. I have not dug into it enough to opine, but thank you very much for that. I'm sure that somebody on Twitter will talk about it and give you a full-on breakdown about why it's appropriate or not. It just can't be me today. Sorry, I have limited bandwidth, and I'm here and we're reading the documents, and we did an hour plus with Vinnie Politan. So that's what we're doing today. But I'm sure that somebody on Twitter will address that, and it is a great question. KCOT Grace says, love your commentary, but I got to ask, what is your beef with e-signatures? I'm going to law school and I want to know the perception among legal folks. I don't know if e-signatures are permissible in Massachusetts. In New York, where I practice, it always had to be an original signature. Now, since the panny and the advent of, getting everything e-filed now, that e-filing is a relatively new thing that has happened in the last couple of years. New York is now all e-filing. I don't think you can physically go to the courthouse and file papers anymore. And so the rules may have changed. And so I cannot advise, I don't know where you're in law school, but congratulations and hope you're doing well. I don't know if you're going right now, if you're going next year, but be prepared to do a lot of reading, hundreds of pages a night. And so the rules may have changed since the last time I was e-filing things. I've been retired a little while now. And so it depends on the rules of the jurisdiction in which you practice. Some may permit an e-file signature. However, it must be an e-file, like you have to sign it. So it looks like your signature, but it's a copy of your signature. It's not an original signature the way we used to old school send somebody to the courthouse to file papers. Maybe just an S/ with typing somebody's name in cursive will suffice. But again, that's a slippery slope, because if your secretary or your paralegal is now signing your name to stuff and filing it without you reviewing it, that's a problem because the lawyer's on the hook for that. So I used to sign hundreds of documents a day and physically sign them. The rules may have changed. I don't really know what goes on up there in Massachusetts because their rules seem to be so much different than anywhere else in the world. Kyle says, I talked to Mike and Abby about how logs persist. Okay, that's fantastic. Congrats. And I talked with Mike and Abby last night. The logs persist unless manually deleted. Cool. In Dallas, we had entire shelves with HDDs and SSDs stored. Thank you. Thank you very much. Back in the day, Courtney became a member. Welcome, Courtney. Right. E-signatures can mean anyone had filed. That's my problem with them. And I don't know if it's my own personal beef. It could, it depends on the court. Is Chloe in the vault? I don't know. I don't know. All right, here we go. Moving on. Docket number 535. Docket number 535. It says filed an error in there, but it's here. I don't know if the error was where they wrote filed an error, but this is a clarification regarding statement in defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCCA. And that's the way that the Commonwealth wrote it. They said Commonwealth's motion to exclude employees of ARCCA. Okay. Did Chloe e-sign? Right, same. MGA boss, MGA. If I'm on the hook for something, I definitely want to read it myself. Just saying. I agree. I agree. I'm with you. Now comes the defendant, Karen Reed, Ms. Reed, and files the instant supplemental affidavit of Elizabeth Little clarifying the following statement, which was included in the defendant's opposition to Commonwealth's motion 4-2, and then it says sick, 4-2 exclude employees of ARCCA. I know what she's doing. I know what she's doing now. This is a cold read, but I know what she's doing. Which I prepared and filed. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. And that was in her opposition at page 1. That is something that Hank Brennan hung his hat on during his last oral argument, which I don't think he put that in his papers either, did he? Refresh my recollection because it is exhausted. They said, well, look, she wrote here, it says they were not hired or paid for by the defense. To be clear, the defense did not hire, retain, or pay ARCCA LLC to engage in the reconstruction, analysis, and or testing that was performed by ARCCA in connection with this case. The defense did, however, reimburse ARCCA for the following time and expenses after trial and after the defense received the ARCCA invoice dated July 12th of 2024, which was provided to the Commonwealth in reciprocal discovery on February 20th of 2025, prior to the filing of the opposition. 1, travel expenses and time associated with traveling to Norfolk Superior Court for the voir dire and trial in this matter. That was on 2 different days, remember. 2, a total of 0.75 hours, less than an hour, in calls with the defense regarding coordinating attendance at the voir dire and trial and discussion regarding experts' background. And 3, time spent testifying in court and the expert's internal preparation for voir dire and trial testimony. The defense did not know what, if any, expenses, that's a little nod to Lally, what, if any, expenses they would be responsible for covering until after the trial in this matter concluded and they received instruction and guidance from the U.S. Attorney's Office. Respectfully submitted for the defendant Karen Reed by her attorneys, Elizabeth Little, XOXO, Alan Jackson, David Yannetti, Robert Alessi, with signatures, real live signatures. And here's 536, which is the supplemental affidavit of, hold on, 536. Okay, so that was a clarification regarding the statement in the motion. And then she submitted also with it an affidavit where she says, I, Elizabeth Little, do hereby depose and state that the following is true to the best of my knowledge and belief. I represent the defendant, pro hoc vice. The facts set forth in the clarification regarding defending Karen Reed's opposition to the Commonwealth's motion 4 to exclude employees of ARCCA filed herewith are true and correct to the best of my knowledge, information, and belief. The statement called into question by Special Prosecuting Attorney Hank Brennan at the last hearing was poorly worded and should have reflected more specifically that the defense did not hire, retain, or pay ARCCA to engage in the reconstruction, analysis, and or testing that was performed by ARCCA in connection with this case. So here she is falling on the sword and saying it was poorly worded. And here's what Hank Brennan was hanging his hat on. It was poorly worded. I'm the one who wrote it. Fallen on the sword. Please forgive me. She says, I personally edited and was responsible for filing the opposition to Commonwealth's motion to exclude employees of ARCCA. The opposition, which included that phraseology, was drafted by a law clerk and no other attorneys worked on the opposition. Not only is she falling on the sword here, she's saying you can't blame Alan Jackson for this misrepresentation because I'm the one who wrote it. No other attorneys worked on it. I'm the one who signed it. I filed it. It is my fault. My fault. Do not hold this against Alan Jackson. XOXO, Elizabeth Little. This is like juggling for the defense team. They are juggling so many balls, right? They have so many balls in the air right now with all of the different things that are going on in this case. This is, you've got the SJC appeal, then that gets denied, and now there's another federal filing that's going on, and that whole proceeding is happening. And now there's motions in limine that need to be drafted, and there's evidentiary motions that need to be drafted. The motion to dismiss needed to be drafted. All of these motions for Daubert Lanigan hearings needed to be drafted. And the opposition to the motions that the Commonwealth has been filing with regard to trying to exclude Dr. Russell. Then there was an entire 2-day hearing on that. The Commonwealth motion to exclude Richard Green, which was opposed and denied on papers. There did not need to be a Daubert Lanigan hearing on Richard Green. And then now this motion to exclude ARCCA, which the defense opposed. And then when they went into court to argue the motion, they were blindsided by Brennan's comments when he got up to talk about this alleged ethical violation by Alan Jackson, lying to the court, perpetrating a fraud on the court. And you can see that she really clarifies it here when she says in the first part of this, here's what we gave. We gave this to the defense. We gave this to the prosecution on February 20th. ARCCA sent us an invoice after the trial on July 12th, 2024. We gave it to the Commonwealth, and that was after the trial. We gave it to the Commonwealth already on February 20th, prior to the filing of our opposition to them wanting to prevent ARCCA from testifying. And it was to prevent them from testifying because they're saying the defense was not able to comply with Rule 14 automatic disclosure because they couldn't provide all of the materials that the feds had given ARCCA to do their analysis and reconstruction. She's saying we gave this to them prior to filing our opposition, so they knew all of this. And here's what the invoice was for: travel expenses and time associated with traveling to Norfolk Superior Court for the voir dire and the trial for 2 witnesses, right? Dr. Rentschler and Dr. Wolf. So travel expenses, time. 2, 45 minutes of time in calls with the defense regarding coordinating their attendance at the voir dire and trial, and discussion regarding background, which is what Alan Jackson said he did. And number 3, time spent testifying in court and the expert's internal preparation for voir dire. So when you see trial prep on there, she's saying we didn't prep them for the trial. They did it themselves. They prepped themselves. They had to read the file. These guys handle tons of cases for tons of different clients. They're hired by the NHL. And I forget what it was that they were hired for the NHL. I think it had to do with the safety glass inside of the design of the hockey rinks to prevent injury. They also did something with seats in, I don't know if it was tanks or something that were used in Afghanistan to prevent injury to the spines of the soldiers. Right. Right. MRAPs for IED blast. Yes. So they handle a lot of different cases, and they have to review the file before they go in to testify, right? Clearly. Hold on. Marvin says for the NHL, they did something with the stanchion that connects the glass by the benches. Yep. Craig says the glass portion of the hockey boards at the benches are now curved to prevent injury. Right. They're highly regarded, and they do a lot of work for a lot of different entities, and therefore they need to review their file before they go in and testify. Right. They were not prepped by the defense. And again, the defense didn't know what, if any, expenses they'd be responsible for. They got the bill. This was talked about in open court, and something like maybe 12 days later, a check was sent or payment was sent to ARCCA after they cleared it with the feds and said, we got a bill. What are we supposed to do? Can we pay it? And they said, yeah, you pay it. It was under $24,000. That is a very light amount for expert witness testimony, prep, travel, and expenses. For two experts to come in, that is very, very light. So it's not a lot of money in the land of experts because, as I've told you several times, a surgeon, I handled so many cases involving experts all the time. A surgeon will charge something like $15,000 plus to come in for a day of testimony. You're going to have to pay it at least 2 weeks prior to the trial because he's going to have to cancel all his surgeries for that day. And if the date gets bumped, too bad, you're not getting your money back. You're going to have to pay again. That's the way it works, especially for medical experts. Accident reconstructionists can charge $10,000 a day for testimony. So for all of this stuff included, I don't think that's a lot of money. And they paid it. Thanks, Courtney, for becoming a new member. Kyle's back. I also had an external HDD. My chief bought to store forensically sound files and records, had to prove many up for chain of custody, authenticity, etc. Yeah, you know. This is your world. Melissa, for the previous comment, that is not a compliant e-signature. It's a cursive font. Thank you, Melissa. I'm assuming that you practice in Massachusetts, or there was a paralegal in here the other day from Massachusetts. And so the e-signature has to be a physical signature, saying it can't be just a cursive font. See, we're learning something every day. Josh says, didn't they pay their digital expert like $13,000 to try an image? Yes, they did. And they were denied that motion when they went to try and get their expenses back for that fruitless trip. So yeah, experts are expensive, very expensive. But sometimes you can't prove your case without experts. Okay, so that was 535 and 536. Let's see what we have next. $537. Go figure. 537, which is more discovery from the Commonwealth, of course. Because, you know, even though they filed their certificate of compliance, they didn't really mean it. They didn't really mean it. It was like, yeah, here's our certificate of compliance saying we're all done giving you discovery. But no, oops, just kidding. Just kidding. We're not done. No, we're not done. My lawyer calls it a wet signature, says in Lemonade Pickets. A wet signature. Yeah, there's ways, right? There's ways of capturing that on your computer, and then you can put it on there. I love how you say my lawyer. I'm assuming that you're paralegal and you say my lawyer. I like that. My liege. How is there still more discovery? Well, we learned the other day that the defense said in the papers that the Commonwealth, when they asked for the adjournment on the motion to dismiss argument, that strangely enough, Hank Brennan picked up the phone and called Alan Jackson, even after Hank Brennan said in court, in open court, like, I don't know how many hearings ago, that he can't trust Alan Jackson to relay their conversations anymore. So he's not going to be able to speak on the phone with him anymore. He picked up the phone and called Alan Jackson and said, oh, hey, guess what? We're going to be producing some chain of custody logs, but, you know, detective is retired. I don't really know when he's going to be able to get them to me because, you know, he's got a tea time and stuff, and he's retired. And also, by the way, we're going to be turning over some more Sallyport video to you on Monday. So, you know, just be on the lookout for that. And Alan Jackson said, what do you mean new Sallyport video? Is it like same as the stuff we already had or different? And Hank Brennan said, I don't really know. I'm not really sure. I don't know. I'm not sure what it is. I don't know. And so that was the reason that the defense is looking for an adjournment, because they're going to need to look at the new video, have their expert look at the new video, put it in their opposition to the motion to dismiss. And then Hank Brennan had the audacity to oppose that motion and say, no, We don't want to give them an adjournment, Your Honor. We're ready to go and argue this motion either tomorrow or Wednesday. So, there's that. Can Geraldo open the vault? Well done, Coach DK. Remember one day we had like an entire discussion about was it Al Capone's vault? All right. For those of you who are too young to remember this, and I don't remember when this was, and Al Capone's vault. This is when, there was only live TV, right? Or not live TV, but we had 5 channels, you guys. We had 5 channels. There were some networks, and you had to watch it live. Maybe it was before DVRs were even a thing. All right, I'm going to have to Google when this was. So Geraldo, there was this whole build up to this. They were going to do this live vault opening. They found Al Capone's vault, and they were going to open it on live TV. And it was this whole thing. And there was a big lead up to this. Oh, this is 1986. Wow. All right. This goes all back to 1986. It was a 2-hour live American television special that was broadcast in syndication on April 21st of 1986. Do you guys remember that? And it was this is the mystery of Al Capone's vault. And Geraldo went and he was going to open the vault. Now that we've fallen into this rabbit hole, we can't get out. I'm just going to we have to take this down. Just for posterity's sake, we're going to go back to 1986 for a minute. Indulge me if you would, because here we are in 1986, and here's Geraldo, and he was going to open Al Capone's vault, and it was a really big deal, and it was must-see TV. Wow, 1986 fashion was wild, right? And he was going to open the vault. And then what had happened was when he opened the vault, there was nothing in it. It was hilarious, says Rachel. And Lindsay's I'll never get those 2 hours back. OMG. There was nothing in the vault. And I don't know. That might have been the day that Geraldo was just that's it. I'm out of here. It says here. I mean, look, it says, what did Geraldo find in Al Capone's vault? When Geraldo Rivera opened Al Capone's vault in 1986, he found dirt, empty bottles, and a small amount of bathtub gin. So that was it. That was the big reveal. It was crazy and wild, and a lot of us remember. That was so funny. All right, we have to laugh, you guys, or we're just going to cry about all of the injustice that we're forced to endure every single day in this mess that is the Karen Read case. And yes, but wait, there's more, because today the Commonwealth has turned over some more discovery in their notice of discovery number 60. Number 60. Oh, that is so funny. I remember another thing, King Tut's tomb. Did they ever do a reveal on King Tut's tomb? I don't remember. All right, now comes the Commonwealth in the above captioned matter and indicates of this date the following discovery and materials have been provided to the defendant through defense counsel. Now comes the Commonwealth in the above, through defense counsel. I just read that. Number 1, copy of MSP report number 108. Dated 2/19/25, which is 32 pages. Hold on. Hold on a second. MSP report dated 2/19/25, which is 32 pages, including attachments. Bates stamped. 2/19/25. Thoughts on what that is? I don't know. And then there's Trooper Lieutenant Tully's notes to MSP report 108. What happened on February 19th, 2025? It wasn't that long ago. Copy of Dr. Crosby addendum to report dated 2/19/25. All right, that has to do with Dr. Crosby, their expert on canine aggression. Number 4, I'm not sure if you sit too close to the camera wall or if it's a tech issue, but you're often out of focus with the focus and clarity on your back wall. It's a new camera, and I think when I move, it's on autofocus, and maybe that's the issue. It's not that I'm too close because I can change that, but then you see too much of the background. It's a new camera, and for some reason I downloaded the I downloaded the like it's only giving me the controls, but I need it to give me the actual like white balance and stuff. Thank you for your concern, and I did notice that also, and I just don't know how to fix it yet, but I'll work on it. Thank you. Wasn't the 19th Proctor's hearing? Well, I mean, this leads me to believe that this has something to do with Cross. Is this when they went and went to visit Chloe? But I don't think that's when they went to visit Chloe. Maybe to say that Fanning wasn't in the courthouse, but again, February 19th. I mean, we're at March 3rd. Hold on. February 19th. I don't know. I don't know what happened on that day, but it has to do with Tully and Dr. Crosby. So your guess is as good as mine, really, at this point. Did I see the articles you sent me about Dr. Crosby? No, I don't know when you sent them. You guys inundate me with emails, and I love it. I can't always respond to you, and especially if you're emailing me during the show when I'm on here live, I can't like stop what I'm doing and pull up your emails. And unless things are fully vetted, I'm not even going to talk about them on the air. So, thank you. February 18th was the blow up in court. This is February 19th. So I don't know. Did anything else happen on? I don't know. Yeah, they went to see Chloe in December. That's what I thought. These could be two totally different things. They could have had Dr. Crosby file an addendum to his report on February 19th. And then this MSP report with Tully's notes could be something different. It just means that they happen to be dated the same date. It's probably the report on the Sallyport video log that they made from the retired officer. No, because he's making that today, like as we speak. He's drafting it, or he drafted it yesterday. So I don't know. Is this when they found like the new video in the paper file? Maybe. I don't know. I don't know. Number 4. Oh, hang on. Okay. I don't know. Frog and throat. Hold on. One more time. Stephanie says Brennan deliberately scheduled Crosby to do something after the hearing was supposed to take place. Don't know. I do not know. Thank you, Melissa. Just got over here, was in a conference call at work, so had to watch Vinny's show first. Not sure why people can't be adults. Everyone has their own opinions. That's what makes the world go around. I know. And I'm going to say it again, and I feel like I shouldn't have to say it, but if you have like comments that disparage my guests or that are defamatory, they're getting deleted. They're just getting deleted. I don't like it when I go on someone else's channel and I give up my time and I give up doing my own show to go on someone else's show and appear as a guest, and people trash me in the comments, and the comments are just allowed to sit there as if like they let their viewers just like trash me in the comment. Like I'm not, not going to do it. That's why I will not go on anybody's channel anymore unless I already have a relationship with them. I know the way that they run their channel. And, I'm not going to let comments like that sit out there about me. And I would certainly not let them sit out there about any creator who comes on my channel. It's just like, I don't get it. I don't get it. But, whatever. It is what it is. You can't change people and you can't fix stupid. That's what I've learned in my many, many, many years of life. So this was February 19th. The hearing was the 18th, right? The big hearing was the 18th. That was the hearing where it was abruptly cut off due to the grave concerns of the judge. And then so this was a report the day after. I don't know. Al Capone's fault. We're still talking. Yeah, I don't know how people do lives without mods either. Smurf Anna, I don't know. Many of you have said that to me about other chats that you go in and they're unmodded and people are just allowed to look. I can't tell people how to run their channels or how to run the world, but I'm going to do it the way I want to do it, and that's it. And I'm not sorry about it. Lisa says Brian Tilley wrote a report after Matt McCabe asked for cruiser cam footage because Matt McCabe was on the scene that morning in a coat. So the troopers took over for Canton some crazy things with the McCabes. Yeah, but that wasn't from February of 2025. He drafted that report because we looked at that report. That report was drafted, I'll tell you, on May 29th, 2024, after Jennifer McCabe testified and after she met with them on the 10th. So that's a different report. Unless I don't know what this could be. Copy of transcript of unredacted Gretchen Voss interview on 6/20/23, which is 257 pages, including word index, which was previously provided to the defense by email on 2/24/25. It is bait stamped and subject to the limitations of the court order. Because remember, Gretchen Voss was required to turn over her entire interview, even stuff that wasn't aired, except she did not have to turn over her notes. She was a reporter for Boston Magazine. Copy of the transcript of unredacted Gretchen Voss interview on July 13th of 2023. So yeah, she did at least 2 interviews with Karen, one on 6/20/23, one on 7/13/23. That one's 87 pages, including the word index, which was previously provided to defense by email, subject to limitations of the court order. Then there's a copy of email to Special Prosecutor Hank Brennan dated 2/23/25, which is 2 pages. We don't know what that is. As he said, he's been turning over all kinds of random emails from people who are emailing him that may have nothing to do with this case. Then there's another copy of an email to Hank Brennan dated 2/6/25, which is 18 pages long. The first one, 2/23, 2 pages. Second one, 2/6, 18 pages, including attachments. Then there's a copy of an email to Hank Brennan dated 2/26/25, 2 pages. Oh, so these actually have dates on them and metadata. That's interesting. It's 2025. It took us to get to 2025 until, now metadata is important. That's an 8-page email on the 26th of February. Then there's another email of 2/17, which is 1 page. Another email to Brennan dated 2/9. That's 1 page. Another email to Hank Brennan dated 2/24/25. That's 3 pages. Copy of voicemails for Special Prosecutor Hank Brennan dated 2/25/25. 2 audio files. Copy of MSP report number 109 dated 2/28/25, which is 3 pages. So these are just like police reports from a couple of days ago. From last Friday. Okay. And then there's another MSP report, number 110, which is also from last Friday. That's 1 page. So one is 3 pages, one is 1 pages. Then there's a copy of a Canton PD report dated 2/27, which would have been last Thursday, which is 1 page. And a copy of reproduced bait stamp 2390 to 2395, which was previously provided on 1/30/25, subject to a protective order. So your guess is as good as mine. XOXO. Hank Brennan, specially appointed assistant district attorney. You know what's not included here are those Sallyport videos that he said he was going to be turning over. But again, this was dated February 28th, which was Friday. And so he said he wasn't turning over the new Sallyport video until today, which is Monday. And so he did say he's turning over all emails that he's getting, whether they have anything to do with this case or are evidentiary in any way, or whether he even is required to turn them over or not, because he's a Boy Scout and he's going to do it all and turn it all over. And that's what he's doing. Barbara Dulong, thank you for your 20. I appreciate you. And then comes again with another 10 watching from Vegas. I'll have to rewatch what I missed. Thanks for covering this. Throw a 20 on number 12 and spin the wheel. Maybe you'll win. Chloe Albert's Revenge. Thank you. Al Capone's vault was like the Epstein files. Yeah. Yeah. I mean, there was so much buildup on that. It was all the way back in 1986. Pepperidge Farm remembers, says Tammy Tebow. And Lola the good dog says Al Capone's niece lived across the street from me. She would have us over and show old family photo albums. My mom would joke that we discovered more than Geraldo ever did just by crossing the street. That is hilarious. You're very funny, Lola the good dog, and thank you for your super chat. Let's check the email and see if anything else has magically appeared while we were covering that stuff. Let us see. I think we've covered it. I think we've got everything that has been filed so far today. Let me just refresh this. And I'm also going to check the dates and see if she's changed the names of any of those hearings for tomorrow. Because tomorrow we're coming back. We have live court tomorrow at 9 a.m. Wednesday, Karen's team will be in federal court in the morning. And then we'll be in Judge Cannoni's courtroom either in the afternoon or when they're finished. I don't know if the time is really set yet. Nope, I've got everything up to 539. And that is the last document that we reviewed, right? Hang on. I believe so. Or wait, maybe 539, because they said filed in error for 534, 535, and 536, which is what we read. And now there's 538 and 539, which have the same title. I don't know if there's any changes to it, and that's why it was filed in error. I don't know if it's any different, but I don't have 538 and 539. I don't know if anybody's got them yet, or if they've even been scanned yet. So I don't know. I do not know. I don't know who hashtag see you at the finish line is, but you've been kind of spamming my email. And if you're going to email me stuff and links, which I'm not going to open, tell me your YouTube username and tell me who you are, because also don't copy me on emails to other people that I don't know, because you're kind of like giving my email address away too. It's also not really a cool thing to do. So if you are a hashtag see you at the finish line, just please kind of guide your actions accordingly. So, there's that. Let's go to the chat for thoughts, questions, comments. There's no videos. So but that was dated Friday. They say they're turning over the Sallyport video today. Thank you, Dennis. The Mentor says, love your new camera. Oh, thank you. I got to figure out how to use it. That's the problem. Like it also like videos in 4K, but StreamYard doesn't support 4K or HD really. So there's really not a need for it. Maybe that's why it's blurry. I don't know. I need a whole tech department, you guys. Need a whole tech department. Lowly's deflated ego says, scares the hell out of me that if I was in Karen's position, I would be spending life in prison because there's no way I could afford this defense. That's another great point. Thank you for your super chat. It is, it's insanity that we're here again for another persecution. My heart goes out to Karen for having to deal with this for 3 years when it is very clear to me that John O'Keefe was not hit by a car and a car did not hit John O'Keefe, because common sense to me, and in addition to my 3 decades of experience as a lawyer handling thousands of car accidents, there would be bumper marks on his body from either the chest down or somewhere on his body, bruising, fractures, something. There's not. And I think that's going to need to be hammered home a bit as well. I thought it was obvious, but I don't know. I thought it was obvious, so I guess it's not obvious. Thank you, Mrs. Bouquet, for your super sticker. There's a 7,400 of you here. That would be so great if you would smash the like button. I'm going to go to the chats for any more thoughts, questions, comments, concerns before General T is like, you're not blurry at all. Maybe they need glasses. I don't know. Thank you. Thank you. Appreciate it. Common sense from just being a person. It's obvious. Swiss miss. I know. I think so too. But I think what we've learned, if anything we've learned is that you never know what a jury is going to do. And that is why it was my opinion that Penny McGee made a really good choice in choosing Judge Cannoni to do a bench trial for her. Because Penny McGee, if you don't know, was on trial and indicted for manslaughter in the death of her ex-husband, who she was living with, had a verbal argument with. She may have shoved him. It's unclear. He dropped dead of a heart attack. She was charged with manslaughter and was looking at 20 years. It was wild. His autopsy revealed that he had a 90% occlusion in both of his carotid artery and his other artery, descending arteries. He also had diabetes. He had had a stroke 6 months prior. He'd had 2 major car accidents where he totaled his cars. He died of a heart attack. Norfolk County prosecutor, again, same courtroom, same judge. She was on trial for manslaughter, facing 20 years. She was smart enough, because she probably watched the Karen retrial, but was not going to risk her future to a jury. And Judge Cannoni quickly acquitted her from the bench on all charges. We watched that together. So that Emmy needs to be your home. The Emmy was like, yeah, well, 2 of them were there. They had an argument. One of them was dead. Therefore, homicide. No big whoop. And you know what else? It was they called it the carotid artery. And every time it was like nails on a chalkboard. It's like, it's a carotid artery. The Emmy in that case was a different Emmy, Rebecca Dietrich. She got on the stand, and boy, did she dig her heels in on this. There were some guidelines that say that a verbal argument can be considered a homicide. If 2 people are in the room, one person wants that. She had a whole story. Here's another interesting thing about Penny McGee. Guess who? And her husband died, her ex-husband died a year before John O'Keefe. In fact, it was like almost 1 year to the day. Like, he died January 28th of 2021. When Rebecca Dietrich, the medical examiner, did the autopsy of Andrew Savitz, whose family is very, very wealthy and very, very well connected, guess who was in the room during that autopsy? Trooper Jeff Kakowski. Ring a bell? Anybody remember Trooper Jeff Kakowski? I'm going to refresh your recollection because it might be exhausted. But do you remember in the text messages between Proctor, DeChico, Kakowski, Fanning, and Buchanan, when DeChico said, rookie move, you should have had me and Jeff do it. You should have had me and Jeff get her to change her manner of death from undetermined to homicide. Jeff is Jeff Kakowski. Jeff Kakowski was in the room during the autopsy of Andrew Savitz 1 year prior. Interesting. Medical examiner was not questioned about whether or not Jeff Kakowski had any hand in or had any discussions with her to change her manner of death from undetermined to homicide in the Penny McGee case. Yeah, it was him. It's not unusual for police to attend autopsies. Sometimes they do. It's unusual for law enforcement to try and strong-arm a medical examiner into changing her manner of death. This was a year before. It was Jeff. He was in the room. I have questions. So when people have a hard time understanding the outrage of the people of Norfolk County, Massachusetts in general, and basically anyone who's had a deep enough dive into the Karen Reed case to get it, this has been going on for decades, from what you guys tell me. So there's that. But boy, did that medical examiner dig in. If you haven't watched the Penny McGee trial, it's only about 4 videos. We covered it together. Go back and watch it, because Karen Reed is not the first time that an innocent woman was persecuted and made to live through years of hell waiting for a trial for charges that never should have been brought for decades. Well done, Lemonade Pickets. Well done. All right, here we go. I don't think there's anything else right now. So yes, Lisa, I am in talks. I'm in talks. Runkle and I are in talks. We're in talks to talk about the insanely shady Brennan. Yes, extraordinary work you do covering this new trial riddled with extraordinary corruption in Massachusetts. Yes, I have been in talks with Runkle. What I would like to do, I'm going to try and put this together and tell me if you'd be interested. I would like to do a LawTube is Outraged stream with Kurt from Uncivil Law, Runkle, Allie and Bob, Mata, and Andrea. So I was thinking that's kind of cool because it's like 3 girls, 3 guys to just talk about how LawTube is outraged about this case and all of the things that we are outraged about. And I don't think that we need anybody on the other side of this, because I don't think we, first of all, can find anybody. But I think that all of us are pretty well established in this LawTube world. We have a lot of crossover viewers, and I think that that would be interesting. And I think that we have a lot of different, we all come from different areas of the law. And I think if Kurt's here, I think he would be into it. I mean, once you start getting too many people on it, it's like nobody really gets a chance to talk. So it's an idea that I'm tossing around. The thing is, when are we going to get to do it? Everybody's in different time zones. Maybe on a Sunday night, it would be good. Maybe depending on what happens this week, we could come on and debrief it afterwards. So I think that would be really fun, right? Yeah. Emmy's like, we watch all of you. We can talk about lawful law. Yep. 4 is a good number. 4 is a good number. 4 is good. 6 is good. I don't think any more than 6 is good, because then nobody could talk. I don't really enjoy going on panel shows that much, because I don't really get to talk that much. So I could just host it and they could talk, because you guys hear me talk and scream all the time. LawTube is outraged, right? Great idea for an outraged panel. I hope it works out. I hope so too. Kat says that he points out to anti-Karen Reed people that, isn't it funny there are no lawyers supporting your position? Well, there are like 1 or 2, I think, on the cesspool of Twitter where I do not play. I left the sandbox about a year ago when they started personally coming for me, because it's an orchestrated team of people and sock puppet accounts that are out there trying to shut up anybody who thinks John O'Keefe wasn't hit by a car. It's out there. It's real. It's happening. I left the sandbox, even though I never really was in Twitter much at all. Anyway, I had an old account, never used it. I never really got it. I was never like, I was always like, what do I have to say? And however many characters they're giving me that anybody's really going to care enough about. Like, I just didn't get it. This was before I was on YouTube. And after I was on YouTube and started talking about this case, that's when they really started coming for me. And I was like, yeah, no, I don't need that aggravation. It's agita. I'm too old for that. Like, I got enough drama. I got teenage girls. Like, I don't need that drama in my life. And I left. But there are lawyers, I think, on Twitter who are touted by the likes of that FBI woman whose name we do not allow mentioned on this channel, whose initials are the same as Jesus Christ. But that she's reposting their stuff all the time. They're so great, blah, 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 blah. I don't know. I don't know. I don't know. Are Massachusetts lawyers afraid to speak out against what's going on in Norfolk County? Because like Vinny said, they got to appear in front of Judge Cannoni, and, might be a little problem there for them in the future. Maybe. So, big case Mike. Oh my God. Big case Mike. Big case Mike. Remember, you guys, if you haven't seen that stream, Big case Mike came on. Was it Court TV? Or was it Law and Crime? Or was it like News Nation? Big case Mike came on and said, Karen Reed, I hate that woman. I hate that woman, Karen. I hate that. He had such personal hatred for Karen Reed. It was wild. We watched it together. We laughed. I can't remember what. I think what had happened was we were watching something live on Court TV that was not on YouTube. And so we had to suffer through the commercials. And then all of a sudden he came on, or maybe we replayed it. I don't really exactly remember because my memory is exhausted. Court TV, he was a clown. Yeah. And boy, did he hate Karen Reed. And he still does, I'm sure. Big Case Mike is not a friend of mine. That was wild. The only other attorney who thinks Karen Reed is guilty and should be stoned before she's hung in Town Square is what's his name? The guy. There's a junior and a senior, Krowski. He represented Colin Albert, I think, at one point, and so he's out there trying to, do whatever he does. And that's another reason that I had Vinny on my show, because the last couple of times they've asked me to come on Court TV, I have respectfully declined because there's no upside for me to be on Court TV. It doesn't help me in any way to be on Court TV. All it does is open up the hell gates, the gates to hell. After I'm on Court TV, the gates to hell open, and it's not. I can talk to you guys for hours, and I can vet who I'm talking to. But you go on Court TV, and that's it. The public lynching happens. It's on. It's real. And so that's the reason why I wanted him to come on here, because I just don't want to go on Court TV anymore. They ask me all the time and I'm like, yeah, I'm really sorry. I'm like, well, wait, who else is coming on? Oh, that person? Yeah, no. Yeah, no. Yeah, no. So there's that. All right. Well, it looks like, oh yeah, the Prosecutors Podcast. I don't know who they are, but yes, I've heard that. Oh, Andrew Myers. Yes, I've seen Andrew Myers. Yes. Solid, level-headed attorney. He's not afraid to speak out. He has a Massachusetts lawyer, right? He doesn't have a crazy Boston, Massachusetts accent. So I do listen to his stuff. I think he's very level-headed, and I do like him. So I do appreciate his commentary. So yes, I agree. And he is Massachusetts, right? And he's currently practicing. So there's one out there, I think, and he's the guy. All right. So here's what we're going to do. We're going to break for now. You're going to want to hit the subscribe button. It's free. You're going to want to hit notifications. You're going to want to set it to all notifications so that if and when more things drop today, we're going to cover them. Also, we're scheduled to be in court tomorrow at 9 a.m. Be there or be square. I will set up the stream later today, but you're going to want to come back for that too. Thank you to the moderators for keeping it classy today for both streams, the Vinny stream and then this stream, because this is not an easy case to cover, as you know. And please help a girl out by sharing the stream, smashing the like button, commenting respectfully, being kind to each other, and all the things that YouTube likes would be really great. I may see you later. So, hang tight, stay cool, stay kind, stay classy. It's not hard. I promise you, it is so not hard. Peace, my friends. I'll see you soon.